Family Law, this is your weeks 12 and 13 guide, and we're talking about spousal support and the division of marital property over the next couple weeks with some projects related to both of those topics. The project's also related to your divorce client, so the same facts unless I change those in an assignment and look for some changes. So what we're going to talk about are the origins of spousal support, the shift from permanent alimony to rehabilitative support, how spousal awards are determined, enforcement mechanisms, how income from support payments are treated, the two marital property systems, community property approach and common law approach, and the property distribution process. Now, we've talked a few times about how we refer to what most of the rest of the country refers to as alimony as maintenance. Before no-fault reform, alimony remained linked to determinations of fault. The idea of alimony as a form of damages as being something that was related to fault. And that's not the case anymore. It was highly gendered in most states. Alimony could not be awarded to husbands. It can be awarded to a husband now. Alimony awards were permanent and incorporated an assumption of continued female economic dependence. Well, we don't have that, obviously. Post no-fault reforms, property division became the preferred way to adjust the post-divorce economic rights of the parties. The focus of spousal support shifted from moral to economic considerations. Spousal support is now gender neutral, and it's no longer premised on the assumption that married women are financially dependent on, incapable of self-support, or dependent on that former spouse. So the factors that go into spousal support: financial need. And I'm assuming you've looked at and read the statute and the other reading assignment I gave you. But financial need, earning potential, age, the duration of the marriage, physical and mental health, income and financial resources, the marital standard of living, contribution to the marriage. Now, typically, states will look at permanent scenarios, lump sum scenarios, or rehabilitative scenarios. Rehabilitative meaning if one of the parties was not working at the time of the divorce, or not working to the capacity that would allow them to sustain their own household, then there was a time period and some support until that person was able to maximize their ability to do that on their own. The community property approach assumes that each spouse acts for the benefit of the marital unit. The contributions of each spouse to the marriage is counted, and each spouse is entitled to a share of the financial gains of the marriage. And then on divorce, the community property is subject to division based on a theory of co-ownership without regard to who contributed what. The common law approach historically divided property according to title. The spouse who owned an asset was entitled to it at divorce. All common law states now divide marital property according to equitable distribution principles that acknowledge that the accumulation of marital assets derives from the efforts of both spouses. So whoever it's titled in, it isn't necessarily representative of who should get credit for that property. Now, when we distribute property, the real property, it's not unlike some of the discussions we've had in other courses. Take, for instance, Wills, Trust, and Estates, when we talked about property. We look at defining the property. Is it real or personal? And we've already been through that if you've taken that class. Property's either going to be real, it's land or attached to the land, something that's titled, or it's going to be personal. Classification, how is it owned? And we've talked about all those different things. So joint tenants, tenants in common. The value of the property, the valuation, which would require that in a lot of cases, especially cases that have large amounts of marital property, you may be involved in helping to arrange or assess or to evaluate appraisals, having all the property or some of the property appraised for its value. And then distribution. In a lot of things, and we've discussed this in the past, we have to consider equity and debt. If you think about, you're probably driving a vehicle right now that you have some equity in. There's some ownership value that you possess, but it may not be paid off. If it's not paid off, you probably have a car loan. So if you were to be in a divorce situation and you wanted to keep that vehicle, we'd have to figure out what is your equity in that vehicle. So say it's a vehicle worth $10,000. And what is your debt? Well, the debt would be, say, $5,000 of that $10,000 value. Your equity in the vehicle is $5,000. The difference between the equity and the debt. If you wanted to keep that vehicle, your former spouse would be entitled to 50% of the equity, but would be responsible for 50% of the debt under that kind of easy $10,000 value. You have to come up with $5,000, or I'm sorry, $2,500, and assume the $5,000 loan. You have to do that math, and that would be true for houses or any other property. Now, I asked you to look at the statute, and so 750 ILCS 5/504 for maintenance, or 501 for temporary relief, which is also something you need to take a look at if you haven't, because we're always going to deal with temporary relief. In a lot of cases, we'll deal with temporary relief to make sure that people can make it until we get to the final judgment. And then distribution of property under 503. So know where those statutes are, go to those statutes, and be aware of what those statutes require. Now, in the Illinois statute, the types of maintenance, we have fixed term maintenance. If the court grants maintenance for a fixed term, the court shall designate the termination of the period during which that maintenance is going to be paid. Maintenance is barred after the end of the period during that fixed term maintenance. Indefinite maintenance is when a court grants maintenance for an indefinite term. The court shall not designate a termination date. Indefinite maintenance continues until modification or termination under Section 510. And then there's reviewable maintenance. If a court grants maintenance for a specific term with a review, they designate the period and specific term and state that the maintenance is reviewable. Upon review, the court shall make a finding in accordance with subdivision B8 of the section unless the maintenance is modified or terminated under Section 510. That reviewable would be that one that would go towards that rehabilitative sort of scenario. So how do we determine net income when calculating spousal support? Well, when calculating spousal support for a new spousal maintenance case, net income has a meaning provided in 505 of the child support, as amended in 2017. Recently revised Section 505 includes an expanded and more concise methodology for calculating net income by relying on either the standardized or individualized tax amount. The standard tax amount means the total of all federal and state taxes for a single person claiming the standard tax deduction, one personal exemption, and the applicable number of dependency exemptions for the minor children of the parties. That includes Social Security and medical or Medicare tax calculated at the federal insurance contribution rate. Parties may use the gross to net income conversion tables using the standardized tax amounts provided by the Illinois Department of Health Care and Family Services on its website, which you are more familiar now since we've completed child support. As for distribution of property, when a court's dissolving a marriage, it'll first look at all of the parties' property to determine whether it is marital or non-marital property. In Illinois, non-marital property includes property acquired before the marriage by gift or inheritance and any income derived from or increase in value of that non-marital property. Additionally, the parties can exclude property that from the marital estate if they have a valid agreement. Because it's not part of the marital estate, the court may not divide non-marital property, nor may it assign it to another party. It must assign it to the proper owner. And that becomes the battle. Is it marital property or not? And that's going to be the thing that you'll be sorting out. All other property acquired during the marriage is assumed to be marital property, and it's therefore subject to equitable distribution upon divorce. Under the Illinois Marriage and Dissolution of Marriage Act, the court may look to the following 12 factors to determine the distribution of marital property. Each party's contribution to the marital estate. That includes the contribution of a homemaker. The dissipation of or by each party of any property. The value of each party's non-marital estate. So how much they have as part of their own non-marital property. Each spouse's economic situation. So if there's some disparity there, the court can consider. Including considering awarding the marital home to the primary custodian of the children. Any obligations or rights arising from prior marriages. Any agreement by the parties, the age, health, occupation, income, skills, employability, estate liabilities, and needs of each party, custodial provisions for children, whether an appointment is in place of or in addition to maintenance, and then the income, earning potential, and tax consequences. So marital or non, who wants it, what's owed on it, and often it comes down to who really wants and can pay for whatever the marital property may be. Now, a little side question out of what I just said, going back to obligations and rights arising from prior marriages. And this came up as a question post our child support discussions. And it's, whether that's equitable or fair that someone may get a credit or benefit because they had other obligations or had other rights from a prior relationship, and how that's fair to the person who's now subject to this second end of a relationship. And quite frankly, the answer is this: buyer beware. If you're getting into a relationship and that person you're getting into a relationship with had prior relationships, and those prior relationships either created a benefit or created an expectation that's going to impact your marital income, your marital property, your ability to run your new household, you got to be aware of that. And you have to understand whether you understand the law or not. Now, you folks very much understand the law. It's just something you take on. So kind of buyer beware. And that's something we can discuss more in class. This is your week 12 and 13 guide. Slides go with weeks 12 and 13 as well. Stay well. If you need me, you know where to find me. And I will see you in class.